Welcome back to the Constitutional Clarion. Normally I don't do videos about foreign constitutional law because it's quite easy to miss relevant details and history and nuance, and so if I do that here, I do apologise. But when the recent decision of the US Supreme Court was handed down last year about presidential immunity, I was asked by a number of US journalists about whether an equivalent immunity exists in Australia. I've been doing some work on that over the summer, which involved reading the US Supreme Court's judgment as a point of comparison. As the day that I'm filming this is just a few days before the inauguration day for President Trump, I thought I'd do a video that explains, particularly for the non-American audience out there, the reasoning of the majority judgment, and to give a foreigner's perspective about what seems to me at least the quite surprising aspects of that judgment. For reasons of brevity, I'm only going to address the majority judgment, which in America is described as the opinion. So the opinion here of Chief Justice Roberts, Justices Thomas, Alito, Gorsuch and Kavanaugh, with which Justice Barrett was in partial agreement. I'm not going to address the concurring and dissenting opinions, although I do note that Justice Barrett's opinion is quite interesting on the issue of bribery. Now, for those of you who are interested, I'll also do another video later, once I've finished my conference paper, which gives a comparative Australian position. As described in the judgment, the case of Trump versus the United States concerned whether the then former president was immune from prosecution for actions taken within the dying days of his presidency, which according to the indictment sought to overturn his electoral loss by making knowingly false claims of electoral fraud and pressuring the Justice Department, the Vice President and state electoral officials to make false claims, undertake sham investigations, prevent the certification of the election results and fraudulently alter the election results. A federal grand jury had indicted President Trump on 4 counts of conspiracy, including conspiracy to obstruct official proceedings and to defraud the United States. Trump claimed presidential immunity on the ground that all of the impugned acts fell within the core of his official duties. The District Court and the Circuit Court rejected Trump's claim. The Circuit Court took the view that if Trump's actions violated generally applicable criminal laws, this meant that they were not properly within the scope of his lawful discretion. There had been previous cases about presidential immunity, and they included Nixon versus Fitzgerald in 1982 and Clinton versus Jones in 1997. In both those cases, the focus of the court was on whether subjecting the president to legal proceedings would compromise the president's ability to perform his or her constitutional functions. This included both the capacity of a sitting president to fulfill the functions of the office while being tied up in legal proceedings in court, and the decisional freedom to exercise those powers without fear that the outcome may give rise to personal liability. The majority of the Supreme Court in the Trump case took a different approach, focusing instead on the nature of the alleged criminal act and whether it fell within a particular category of power with respect to the president. It established 3 categories. The first category was variously described as the president's conclusive and preclusive constitutional authority, or the president's core constitutional powers. Anything done within that category, according to the majority, was covered by an absolute immunity from criminal prosecution. The second category is the rest of the president's executive power, which is not exclusive but may be shared with Congress. If an act falls within what was described as the outer perimeter of that power, it gives rise to what the majority says was at least a presumptive immunity. The majority said it was unnecessary at this stage to decide whether this category did fall within absolute immunity or a presumptive immunity, and it left that issue open. Acts within this category done by the President of the United States could not be prosecuted unless the government could show that applying a criminal prohibition would pose no danger of intrusion on the authority and functions of the executive branch. The third category is unofficial acts. All parties to the case accepted that the President has no immunity in relation to unofficial acts. However, this does raise the question of how far the President's official powers go and what evidence can be used to establish wrongdoing in relation to unofficial acts. And I'll come back to that later. So let's look first at the narrowest category, and that is of the President's conclusive and preclusive executive power, which gives rise to that absolute immunity. In identifying this, the majority turned to cases about the separation of powers, including one very old one. So we know that one of the powers of the President is a power to grant pardons. After the United States Civil War, the President of the United States did offer pardons to those who had engaged in rebellion if they swore allegiance to the Union. And those pardons were stated to include the restoration of property rights. Congress, however, enacted a law that made it unlawful to rely on such a pardon to restore property rights. The Supreme Court then held, in the case of United States v. Klein in 1871, that the law was invalid because the Constitution conferred upon the President alone the power to grant a pardon, which included the effect of that pardon. Congress, therefore, had no power to alter that effect. In the Trump case, the majority of the Supreme Court saw Klein as being about presidential immunity, arguing that not only was the power of Congress limited by the Constitution, but that the President, in exercising the power to pardon, was also immune from scrutiny by the judicial branch as well. It then applied that proposition to the allegations made in the indictment against Trump. And these allegations were that he sought to overturn the legitimate results of the 2020 election by attempting to use the Justice Department's powers and authorities to convince the states to replace their electoral college electors with Trump's fraudulent slates of electors and to make sham allegations and initiate investigations of electoral fraud for improper purposes. The majority of the Supreme Court held that these interactions with the Justice Department fell within the President's exclusive authority over its investigative and prosecutorial functions. Accordingly, the majority declared, quote, "Trump is therefore absolutely immune from prosecution for the alleged conduct involving his discussions with the Justice Department officials," unquote. From a foreigner's point of view, that's actually quite shocking. It gives the President carte blanche to use the Justice Department to initiate investigations of the President's enemies, to do so for improper purposes, and to seek to overturn the most fundamental pillar of democracy, an election, simply because he does not like the outcome. Would the Founding Fathers of the US Constitution really have intended the Constitution to give absolute immunity to a president who seeks to overturn the operation of that very Constitution? It seems unlikely to me, especially as the President is required by the Constitution to take an oath to preserve, protect, and defend the Constitution of the United States. All right, what about the other two categories? One problem is that it's necessary to draw some kind of dividing line between official and unofficial conduct. How do you do that when the Constitution is vague about the full scope of the President's discretionary power? A second problem is that the type of power we're dealing with here is non-exclusive. It can be regulated by Congress, which can pass criminal laws regarding its exercise. On what basis then does an immunity apply? On the question of the scope of the President's power, the majority held that presidential conduct can be official even when it's not obviously connected to a particular constitutional or statutory provision. The president's immunity, therefore, quote, extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority, unquote. Now, that's an extremely wide field of immunity. But even more extraordinary was the holding of the majority that in deciding what was official or unofficial conduct, no inquiry could be made into the president's motives, such as whether he or she was acting for an improper purpose. This was because executive action would be exposed to intrusive scrutiny upon a mere allegation of improper purpose, defeating the purpose of the immunity. So if the president performs an act in return for a bribe or because he's taken an intense dislike to someone, it cannot be argued that it's an unofficial act because it falls outside the scope of the power which was conferred upon him for particular purposes only. Instead, it's deemed to be an official act that gives rise to presidential immunity. Equally, the majority held that a court must not deem an action unofficial because it violates a generally applicable law. Otherwise, presidents could be subject to trial upon every allegation of unlawful action. So a president can use their official powers in a manner that breaches the law and for corrupt or even unconstitutional purposes such as overturning a valid election, and do so with legal immunity. Again, as an outsider, I find it hard to fathom that a president is acting within his or her official duties when taking a bribe or committing treason, or why the Supreme Court would want to encourage such behaviour by guaranteeing the perpetrator immunity from doing it. So, how did the majority of the Supreme Court apply that reasoning to the rest of the indictment? Part of the indictment was directed at Trump's attempt to get the Vice President to use his role at the certification proceedings on the 6th of January, quote, to fraudulently alter the election results, unquote. The Vice President's function at the certification was part of his legislative, not executive, role as President of the Senate, and Congress had exercised its powers to legislate concerning the Vice President's legislative role. Trump's actions, therefore, did not fall within his conclusive and preclusive executive powers. But the majority noted that the President may rely on the Vice President to advance the President's agenda in Congress, such as through a tie-breaking vote. The majority then said this, quote, applying a criminal prohibition to the President's conversations discussing such matters with the Vice President, even though they concern his role as President of the Senate, may well hinder the President's ability to perform his constitutional functions, unquote. The majority concluded that it was up to the government to rebut a presumptive immunity of the President and that the District Court should now assess whether Trump's alleged attempts to influence the Vice President to overturn the election would pose any dangers of intrusion on the authority and functions of the executive branch. As for the allegations in the indictment about Trump's pressure on state legislators and electoral officials to change the outcome of the presidential election, and whether that fell within the president's official functions, the majority of the Supreme Court had the audacity to suggest that it may fall within the president's duty to take care that the laws be faithfully executed, which, they said, plainly encompasses enforcement of federal election laws passed by Congress, unquote. In other words, the president's duty to ensure that the law is faithfully executed gives him immunity from prosecution for breaching that very law in the most fundamental way by seeking to overturn a valid election. Wow, what can you say to that? Quite extraordinary. Now, in this case, the majority then complained about a lack of factual information on this issue, and it remanded the issue back to the district court for determination. What about unofficial acts for which the president has no immunity at all? The problem here is twofold. First, the Supreme Court has set the scope of presidential discretionary powers so broadly and the test at such a high level that something will only be regarded as an unofficial act if it can be established that it is manifestly or palpably beyond the president's authority. In making that assessment, one cannot take into account the motive or purpose of the action or that it breaches the criminal law. The second problem is an evidential one. A majority of the court held that evidence about official acts, such as those that show the president's knowledge of certain facts and events, cannot be used in criminal proceedings in relation to unofficial acts. For example, in separate proceedings, it appears that President Trump intends to appeal a conviction for unofficial acts of falsifying business documents to conceal a hush money payment on the basis that some of the evidence used in that trial concerned official acts within the extraordinarily broad definition of that. So, coming back to the Supreme Court's case, why did the majority decide that way? First, its judgment shows that it was concerned that the risk of prosecution would deter the president from taking the bold and unhesitating action required of an independent executive, that it would inhibit him from executing the duties of his office fearlessly and fairly. But the alternative point of view would be that maybe it's a good thing to deter a president from taking bold, criminal and corrupt action, and that maybe the risk of prosecution might cause a president to act fairly and lawfully, which ought to be a good thing in a democracy based upon the principle of the rule of law. Second, the majority was concerned about tit-for-tat actions with each president prosecuting his or her predecessors. And yes, that's a real risk in these hyper-partisan times. But surely it's better dealt with in other ways, such as independent prosecutors and the strict application of the rule of law. As it is, the majority's judgment gives absolute immunity to a president who uses the Department of Justice to get a former president's loved ones prosecuted. The judgment therefore accommodates and gives immunity for tit-for-tat prosecutions, just using a president's family instead as the victims. And what should the rest of the world make of the prospect of a president of the United States who can act with impunity in breach of the law, knowing that he has complete immunity from prosecution? In my view, taking off the guardrails of the rule of law, especially for a person who holds great power, is a very dangerous thing. Thank you for watching the Constitutional Clarion. I hope this fills in some of the blanks for you and gives you a better idea about what's going on. And as always, I look forward to seeing you again next time. Goodbye.